You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome back to NCR 525, which is our course on mediation. Now today we're going to dig deeper into the concept of storytelling. This is identified as our second stage of mediation, and of course you've heard me go on record before saying how we number the stages doesn't necessarily matter. What matters is that we understand what the issues are. So this stage is where we have the disputants tell their stories and we try to understand what the underlying issues are. Now, the first thing I'll tell you as a practitioner of mediation is that sometimes disputants will come into a setting and they understand clearly what their issues are. And then other times you might have the far extreme where we find that disputants actually don't understand what their underlying issues are. And although you might be able to identify them right off the bat, the process of storytelling is our way to unfold those issues for the mediator to check what he or she perceives them to be, and also for the disputants to hear how all of the ideas are related. So, in other words, it's hard to say what you're going to get. Now, you've heard me talk about this other analogy that I use is the analogy of the sandbox. If you're a mediator and you step into a situation, maybe with very little intake, and you approach a sandbox, so to speak, looking for the main objects, you could start at any end of the sandbox, and you might get lucky and identify an issue by stabbing the sandbox and looking for any kind of object in the sand. You might hit something immediately and say, wow, we have an issue here. Or you might spend a lot of time stabbing without finding out what the issues are for some time. In other words, it's not really controllable. And that's something I think is hard for mediators to understand, is that sometimes you can say, why are we here today? And people will start with, why aren't we here today? Or, of course, it's a long story. Let me tell you every detail, big and small. Even when sometimes I ask disputants, what are the main issues? Or what do you think are the 2 or 3 main topics we should talk about today? They still might give me some very small topics along with very big topics and not be able to distinguish among them. Now, of course, as a trained mediator, you will be able to apply your skills, just as I do, in order to try to help individuals identify their issues. So today we're going to cover 5 different topics. And these are main topics that we talk about in terms of the idea of mediation storytelling. We're going to talk about specifically about asking questions. We'll discuss perspective taking. We'll look into the idea of paraphrasing. We'll explore whether we can really be neutral in our phrasing, and then we'll identify positions and interests as a way to think about bridging some gaps between our disputants. So let's start with that first topic of asking questions. As we explore that first topic, we want to just kind of think about it as an overview of some information that we already know. Now, sometimes people will say to me, as a teacher of communication, specifically interpersonal communication, what do you believe is sort of the duct tape of communication? And I kind of laugh at that question and say, what do you mean duct tape of communication? And the question is saying, is there any one skill or tool that you believe has a lot of functions? So if you think about duct tape, it like repairs our lunchbox, it holds the mirror on the side of our car, it fixes the bottom of our shoe. We use duct tape for a lot of different things. And so when I'm asked what's the duct tape of communication, I would say it's the question. Because the question in any kind of context, including mediation, has so much utility. And so it means as you and I develop our communication skills, we have to be better at asking questions. We have to understand the pitfalls of questions that don't work as well as others. And so let's take a look at this next clip and look at some overview ideas or overarching ideas around the notion of asking great questions.
Voltaire said, "Judge a man by his questions rather than his answers." And he makes a very good point. It's often said that the quality of your life is defined by the questions you ask, because the quality of the question determines the quality of the answer. So it stands to reason that if you can get better at asking questions, then you can get better answers. Better answers result in a whole host of benefits. For example, being better informed allows you to make better decisions. But being better at answering questions doesn't just mean getting better answers. Obtaining information is just one outcome of questioning. Questions can be used for controlling a conversation. This can be particularly useful during an argument or negotiation. Questions can also be used as a way of showing interest. Showing an interest in other people can help to build relationships, and showing an interest in a subject can open up opportunities to become involved. What's more, questions can be used to explore people's personalities or to diagnose problems, as well as being the common way of testing people's knowledge, such as exam questions. Questions can also be used to encourage further thought or used to emphasize a point. For example, this can be done using a rhetorical question. Finally, ever heard of an icebreaker? Well, questions can be used to encourage a discussion amongst a group and promote conversation amongst people who don't know each other. So it's worth considering how skilled you are at asking questions, because although we all know how to ask a question, do we all know how to do it properly? Questions in their simplest form can either be open or closed. Closed questions are questions which require a short answer, often one word, and chosen from a limited set of possible answers. For example, yes or no questions, or multiple choice questions, or a question to get a specific piece of information. Let's look at some examples of closed questions. Would you like an ice cream? What flavour would you like? How much does it cost? In contrast, open questions allow for much longer responses and therefore potentially more creativity and information. An open question asks the respondent for his or her knowledge, opinion, or feelings about something, and the response is usually more qualitative than quantitative. They usually begin with what, why, or how, but tell me and describe can also be used in the same way. Here are some examples of open questions. Tell me what happened when your ice cream was stolen. Why did you not report it right away? How was your day out at the seaside? There are a few advanced questioning techniques such as leading questions, probing questions, funneling, and rhetorical questions. Let's now take a look at how they work. Simply put, leading questions are where you lead the respondent towards giving you a particular answer which is more favourable to you. For example, if a salesperson asks you, "How many widgets do you want?" then the salesperson has assumed you want some. To answer the question with a number means you've been led to an outcome. However, you must use leading questions with caution because they can be interpreted as rude and manipulative. Probing questions are questions which force the respondent to think more deeply about the information they recall for their answer. For example, if you use a word like exactly in the question, it forces the respondent to be specific. Funneling questions allow you to cleverly funnel the respondent's answers. You do this by asking a series of questions that become more or less restrictive at each step. You start with open questions and end using closed questions, or vice versa. For example, have you been to any good parties recently? What did you do at the party? Was any food provided? Did you eat jelly? The questions in the example become more restrictive, starting with open questions which allow very broad answers, and at each step the questions become more focused and the answers become more restrictive. Rhetorical questions are often characterized by being questions which do not require an answer. Sometimes the question is unanswerable, but usually the answer is obvious. So obvious, in fact, that you wouldn't answer it. It has been asked to demonstrate a point and said for effect. Okay. Do you want to know a secret skill about questioning that is left out of many courses? It's the importance of silence. When you ask a question, no matter how awkward you feel, try to be quiet and let the other person answer. As we've just discussed, unless you're asking a rhetorical question, the purpose of a question is to receive an answer, so be sure to give the respondent the time to answer. And while we are talking about responses, how you interpret the response is equally important to the question. For example, you could ask the best question in the world, but if the answer is a lie or you don't get an answer, what good was the question? Watch out for respondents who only partially answer your questions or stall when responding. Politicians are well known for avoiding the question by giving an unrelated answer, so consider what type of response you are expecting and have a suitable method for making a record of the answer.
So I suspect that a lot of the information in that video is information that you already know. But when we start to apply that information to the concept of mediation, the challenge is very apparent. You and I have to come up with questions that get to the bottom of where those issues lie. And we're trying not to lead people, we're trying to discover. And so we try to use questions strategically to get to the issues. Now, one of the topics that's talked about in that video that I love is the idea of silence. And this is something that individuals tend to sometimes get in the habit of even answering their own questions or not holding space for someone else to maybe think or gather their ideas together to answer a question. So as you're thinking about silence, challenge yourself to create silence that's even maybe longer than is comfortable. You know, hold silence. Did you know that the average teacher tends to wait under 3 seconds for the answer to their questions to a class? And that is very interesting to me because when we think about this concept we call teacher wait time, that's the name of it, the wait time is frequently so short that there's a whole part of the class that's left out of having responses in the classroom. And that notion, because we see it across all kinds of classrooms in the United States, that notion is challenging for you and I as mediators to say we really need to become comfortable with silence and give people that space and allow ourselves to handle that and be comfortable with it. Okay, I want to talk about a couple other ideas that came out of that video. One thing that it talked about is how we phrase the language of the question. And this is something that when I train mediators, I really am fairly picky about. Sometimes mediators will say, "Can I ask you a question?" Or, "Would it be all right if we had a caucus?" And my comment would be, please don't do that. And the reason is that you need to be more directive for 2 reasons. One is to give your disputants a better sense of instructions, and 2 is to keep control. So instead of saying, "Can I ask you a question?" say, "I'm going to ask you a question." Or instead of saying, "Can I encourage you to do a caucus?" or "Would it be all right if we did a caucus?" I'll say, "We're going to do a caucus format now." And then I might explain the caucus format. The point that I'm making is remove that qualifying clause at the beginning of that direction or question so that you maintain a higher level of control. You don't have to be mean in your delivery, but just think about the microscopic phrasing of your actual sentences so that you become better at having that control, but with a very calm and persistent demeanor. Now, one other comment I want to make before we get into leading questions, which we'll talk about in a second, is this notion of demographics, and that's kind of the name for that kind of questioning that I talk about in mediation. Sometimes mediators fail to grab the most basic demographic piece of information. So for example, let's say you have a roommate dispute and you're doing a mediation for the roommate dispute and you see that they have a lot of common area issues. And what I would say is it is very important probably to understand how many bedrooms and bathrooms are in that apartment. And sometimes mediators go for the issue and they go for maybe the more complicated issue without gathering the context for that complicated issue. So if I have a neighbor-neighbor dispute, sometimes I'll have neighbors that live 3 doors down from each other, and sometimes I'll have neighbors that live next door to each other or across the street from each other. And I need to know that basic information. When did you move in? Maybe understanding who moved in first is a basic demographic piece of information. Is there a lease agreement? Do you own your home? How long have you lived there, I said. Where is your house? Sometimes I'll have disputants actually draw on a piece of paper the layout of a property line, any of those kinds of things. And here's what I would say. From my experience, if you have that context, then you understand why the fence is such a problem, or why the noise is such a problem, or how that 2-story house next door to the 1-story feels like they're looking at them because they maybe video out of the upper story. I just had a case that involved that. When you understand the demographics, then you understand what's happening in terms of what they're saying. I had a case a while back where the one neighbor was accusing the other neighbor of exposing their children to marijuana and the smoke from that. And immediately I went for the demographics to understand who lived where and why that was the case. It turns out they lived one on top of each other in terms of apartments or a condominium. And that is important to understand how that relates to the exposure of the children that they were talking about. Okay, so the next thing the thing that you saw in the video that I want to talk about is this notion of leading questions. And of course, everybody talks about leading questions are bad, and why they're bad. You saw in the video, it leads someone in a direction that you wish them to go, and that is precisely why in mediation, it's not useful. Let's take a look at this next clip on leading questions to remind us about that structure.
All right, I want to talk to you now about actually when you ask the questions to the person you're interviewing. We've already established that we'd rather have some open-ended questions so that the answers can be, discussion can come out of the answers rather than just yes or no. But something that's real important is what we call neutral phrasing. And neutral phrasing is asking the question in such a way that I do not sense your view on it. Like, I'm going to go back to my question about Iraq. Closed would have been, should we pull the troops out of Iraq, yes or no? And then we had, do you think we should pull the troops out of Iraq? Or what do you feel about pulling the troops out of Iraq? Well, that's neutral phrasing. What you don't want to do is say something like, don't you think we should pull the troops out of Iraq? Because what that's doing is leading. You've heard of leading the witness? All right. That means you're trying to get a certain answer out of your expert. And you don't want to do that. You don't want to lead them so that you get the answers that you want. Allow them to be the expert and answer the questions that you ask expertly. You'll have a better interview that way.
This video reminds me of a very important concept that I like to think about. And that's the question, am I building the narrative in my head or theirs? And that's kind of an interesting thing to think about. Like, am I asking a question so that I can answer the narrative that I'm starting to form for myself? Or am I asking the question so that they can understand and promote understanding between the disputants? And that's kind of an interesting question to say, where does the story lie? And what are you doing with that leading question? Generally, leading questions don't work very well in mediation. And we can talk a lot about neutrality. We'll do that in a few minutes. But the notion that I lead someone somewhere seems a lot more about me and a lot less about them. Now, one of the aspects to talk about in terms of question asking is to identify the probe. And that's the follow-up question. And you've heard me say already that we like to, or it's important to stay in the mode of question asking and probe over time. So maybe even stay in that line of questioning longer than you feel maybe comfortable, maybe using silence to try to get a little more information. My rule of thumb is if I keep getting value, I stay on that line of questioning. If I get repeated information, I don't necessarily stay on that line of questioning any longer. And that's the same with the disputants, and that's the same with the stage. So let's think about that idea. When I'm getting repeated information from a line of questioning, I might change the line of questioning. And then when I get repeated stories from the disputants where I'm not getting additional storytelling, I don't have new issues coming up, that's the hallmark of when it's time to move to another stage, to go forward. And so I use that kind of as my own rule of thumb, saying I don't have new discovery. Some people, when you get them into mediation, will have a million examples for the same issue. And so when I hear one example, and then I hear that issue identified, and then they say, well, the other day this happened, and they give me a similar example, I'm not going to ask them for more examples. I'm going to ask them for more issues. Because some people have endless examples, and all I'm doing is getting more information about the same thing that I already know. So think about whether it's new discovery versus existing discovery. I want to talk about another concept that happens in small claims. So one of the things that happens in small claims is that individuals will sometimes file for dollar amounts that are different maybe than the receipts they have brought to the court. So let's think about what small claims is. So we have small claims, which is the court, the mediators I work with call it the court of quantifiable loss. It's the court where somebody's lost some amount of money and that documents are very important in that particular court. So remember, this is where we don't have attorneys. Individuals represent themselves, And as you think about it, the maximum dollar amount is $10,000. So when I get a sheet, and so the intake on these cases is very small, I might get a sheet, and as a mediator, I look at that sheet, and on it says the name of the parties, the plaintiff and the defendant, maybe a sentence about the case, and then the suit amount. And so one of the things that I always think about as a mediator is when I get handed that sheet and it says 10,000.00, I think to myself, did they just seek the maximum just because they felt like just asking for the highest amount possible? Or are there receipts to substantiate that claim? Sometimes I'll get a case that is for, I've had one before, $285.52. Now, usually when I see that piece of paper, in contrast, I think, boy, there's probably a receipt, because people don't normally file for amounts that have cents on them, right? They got to that dollar amount some way. So when you're mediating a situation of like quantifiable loss, like a small claim suit, one of the comments that I would make as a mediator in that area is to ask how the parties got to that dollar amount. And sometimes I've had people say, because I'm very, very mad. And part of the challenge is that you need receipts. So you can say, do you have any documentation that would help us understand the emotional dimension that you're talking about? So people say, oh, I lost work, or I became depressed, or there's different things that people say that are harder to get a receipt for. But people sometimes have days lost work, or they have counseling, or they've seen a physician, and sometimes that can be documented. But as a mediator, I think it's kind of interesting to think about questioning how they got to that dollar amount as opposed to assuming how they got to the dollar amount. And so that's what I do. When somebody says, oh, I'm suing for $8,000, I'll say, tell me what the $8,000 includes. And I'm using a follow-up question to find out that information. Now, the other concept I want to talk about here is kind of an interesting thing that I had to learn when I was mediating, and that is sometimes in the stage 4, people will say, you know what, let's just split it down the middle. And now where I come from, and this is bias showing up, so this is a challenge as a mediator, is where I come from, splitting down the middle is 50-50. That's what I grew up thinking. And I have had more than one time in cases where, let's say it's $1,000, and I'll say, the parties will say, split it down the middle. And if I say, well, tell me what the math is on splitting it down the middle, they'll say, I get 600 and they get 400. And they truly, with an honest face, that is how they believe splitting down the middle works. My comment about all of it is we have to just forget all of the things that we knew personally going into that mediation and challenge ourselves to just ask, what does that mean? Now, I've also had people look at me like, what do you mean split down the middle? 50-50, of course. Like, are you stupid? And I always take that risk anyway, because I've had, I don't know, half a dozen times where somebody split it down the middle and it wasn't 50-50 math. Now, the next thing we want to talk about is the topic of perspective taking. And one of the issues that we have in mediation, of course, that's inherent to it, is that the parties don't necessarily understand the perspective of the other party. And so this is a challenge for you and I to try to work as a mediator to show that perspective taking or to facilitate that perspective taking in order to possibly establish common ground or to help the parties just see the other perspective. So sometimes in common ground, for example, well, actually, I would say from experience, when I do civil harassment cases that are neighbor-neighbor, there's a very obvious common ground that happens almost every time. I will ask them, what are you interested in at the end of the day from this mediation? And they will answer the same question almost every single time, peace. They want to live in peace. They want to just go about their way and not have conflict in their neighborhood. And so sometimes in mediation, when that appears, you can, as a mediator, when they've already put it on the table, right? You don't put things on the table, but let's say they both parties express that. You can say, what I'm hearing is that both of you want peace. And that's a way to kind of think about common ground. It's also a way to grab the perspective and join it together. Now, when we think about perspective taking, remember, this is where I challenge the disputants to see the vision from the other party's perspective. And so there's a whole bunch of ways to do that. But before we get into some of that, I'd like for you to take a look at this next video. It's Dr. Daniel Pink from Georgetown University. And this is a very interesting experiment that they conduct on perspective taking.
I'm going to give you 3 very simple instructions. Instruction number 1, identify your dominant hand. Instruction number 2, with your dominant hand, snap your fingers 5 times very quickly. Awesome. Instruction number 3, with the forefinger of your dominant hand, the pointer finger of your dominant hand, on your forehead, draw for me a capital E. Excellent. This is an experimental technique that social psychologists have used since the early 1980s to measure what's called perspective taking, the ability to get out of your own head and see things from someone else's point of view. Snap your fingers 5 times quickly. What's that instruction about? Nothing. It's just a distraction. Finally, you get to the part that the researchers really are looking for, which is this. There are 2 different ways to draw the E. All right, I can draw it like this, so you can see it, your perspective, or I can draw it like this, so I can see it, my perspective. Put people into an experimental setting, control for handedness, make them snap their fingers, ask them to draw an E. What do? Do they take their own perspective? Or do they take someone else's perspective? If you drew the E from your own perspective, it doesn't mean you're a bad person. Because what really matters here is context. In general, the more powerful people feel, the more their perspective-taking abilities degrade. All of you are about to become more powerful. Some of you will begin drawing the E differently than you drew it today. If you gradually lose the ability to see the world through another's eyes, all the experience and expertise you've accumulated will melt into a puddle of unrealized potential. But if you work to balance power and perspective taking, you'll become a more effective leader because you'll offer reasons beyond "I said so" for why anybody should follow you. You will avoid what could be the biggest mistake that bosses, teachers, executives, government officials, and anyone else in a position of power can make. And the mistake is this: thinking you're the smartest person in the room. If you think you're the smartest person in the room, you've just proved that you're not. Believing that you're the smartest person in the room, trust me on this, never ends well. Remember the lesson of the E. Argue like you're right, but listen like you're wrong. Use your power, but sharpen your perspective taking.
So we can see some really interesting commentary from Dr. Pink about this notion of perspective taking. We bring it up because when you think about helping individuals to get that greater context, to open their eyes, to see, even if it's temporarily in mediation, then it opens the doors for a lot more possibility. And you kind of saw that from their research. So it's a very interesting perspective-taking tool to use. And when we enact it, you know, it might be about feelings. It might say, Charlie, how do you feel about this? And how do you feel the other party feels about this? We might ask, what do you think the other party thinks about this? Or what do you think the ramifications are for the other party if this were to be something that we adopt? You can think about how perspective taking can really open up a broader level of understanding, even if it's just temporary to the mediation session itself. Now, the next topic we're going to talk about is paraphrasing. And I want to distinguish paraphrasing from parroting. So one of the common mistakes that people will make is they'll say, I'm going to paraphrase. And instead, they will parrot. So you remember what a parrot does. They say, Johnny wants a cracker. You say to the parrot, and the parrot says, Johnny wants a cracker. Remember, parroting is not transforming the words, the thoughts, or the feelings. It's just repeating back. So when we talk about the skills of mediation, parroting is really not as helpful. Occasionally, I might use it. But honestly, it's pretty rare. Paraphrasing is this notion that you give me a jumbled message of thoughts and feelings, and maybe like a Rubik's Cube, I put it into a new formation, and then I hand it back to you and say, I heard that you think this and feel this way. And so we're using paraphrasing as a way to reflect that same idea back to the person who gave us that message in the first place. But it has to be transformed. So it can't be just parroted back. It has to be actually changed so that it's in a new formation so that it is now on display in the mediation for both parties to see. Now, let's take a look at this next clip and as it talks more specifically about paraphrasing.
If you want to show you're listening, then you need to master reflective statements. Reflective statements are
So as you can see in that reflective video, they are taking the notion that I just talked about, and that is reflecting back what that party has actually given you in the first place. But remember, you have to put it in your own words when you're truly paraphrasing. So whether that's facts or feelings or thoughts, we put it in our own words and then we give it back to the disputant, and we might even ask the question like, is that correct, or is that right, or is that what I hear you saying? We might actually have a clarifying question on the end of that paraphrase in order to elicit a response of confirmation. Now, once we do get a paraphrase out there that they confirm, then we can use it as sort of a platform to go forward in mediation. I call those like planks or pillars, where we can start building a foundation of movement in the mediation process. Now, of course, all of this really counts on the neutral third party element of mediation. Now, I want to kind of delve into this idea of neutral phrasing a little bit. There are some individuals who believe that we can't actually be neutral, that is actually impossible. And I might tend to agree with that. But let's hear from this expert, Bruce Edwards, who talks about the problem of neutrality in mediation.
Mediators are often defined as being neutral, sometimes described as a professional neutral. I describe this as the neutrality myth. Why? Because we know from brain research that every human being is shaped by a lifetime of experiences and perceptions that come from emotional events. Therefore, we understand there's no such thing as a neutral perception or a neutral mindset. It's imperative that we discourage new mediators from thinking of themselves as neutral. Rather, our success in training will start with developing a self-awareness that we are all biased. Not necessarily implying prejudice, but simply in how our brains perceive information. The goal for advanced mediators is to become conscious about why we are reacting in a given way in a particular moment, and, if necessary, to actively overcome that bias as we attempt to treat each side fairly. This process of equal attention in the presence of bias I've come to call omnipartiality, which describes the active process required to treat people fairly despite our bias and our humanness.
Now, that's a very interesting point of view. I do agree with Bruce Edwards that this notion that we can't be probably entirely neutral is really impossible to achieve. But it kind of points out this challenge in mediation. And that is, if the issue is that I insert my bias and that comes from me, then you and I have to become very, very skilled at understanding our tendencies as communicators. And so I would challenge each of you to think very strongly about what tendencies you have interpersonally that you might bring to certain situations. And do those show up? So for example, if you're someone who is very competitive, that's something that is in my profile. As a competitive person, I tend to immediately bring a more win-lose mentality. And I have to fight that so that I can be a good mediator. And in fact, I can be a good mediator. I believe everyone can. But you have to train yourself to know where your impact might show up on any level in the mediation. Now, I want to talk about this idea of neutrality really related to the notion of suspending judgment, because I think being judgmental is at the heart of one of the main issues that forces non-neutral behavior. And I'm going to use those terms loosely because you heard the video. Maybe it's impossible to achieve. But as we strive for neutrality, okay, maybe we'll say it that way. As we strive for it, one of the enemies of neutrality is judgment. So here I would cite the writings of Dr. Brené Brown. Now, some of you may be familiar with her book. The book Rising Strong is the book that I'm talking about in this section. And she plays and explores the notion of judgment and what it does to us interpersonally. So she poses one simple question, and that is, do you believe fundamentally that people are doing their best? And as you think about that question, it's very, very interesting to contemplate, and I don't mean in mediation yet. I just mean like fundamentally as a person, do you believe people are doing their best? Now, in this book, Rising Strong, she has a whole chapter devoted to this question. The question that she immediately answers, no, people are not doing their best. I know I'm not, so other people aren't. And when she explores the beginning of that chapter, she talks about lots of ways that she was trying to set out to prove that people weren't doing their best. So she goes and talks to lots of different professionals, friends, all kinds of different people. And ultimately, she can't really solve that puzzle because there's really no way for us to know whether people are doing their best. But if you're familiar with the work, you know that at the end of that chapter, she has a conversation with her husband, Steve, who is a pediatrician. And Steve is posed with that same question. She's been on this quest to answer this question, are people doing their best? And so she says, Steve, do you think people are doing their best? And Steve pauses, and then he says, I don't know. But he says, I know that when I believe they are, I'm a better person for it. And so that is a very interesting thing to contemplate now as we talk about it inside mediation. Do you believe people are doing their best? Because when I'm in a mediation, I think about the fact that my disputants have failed in some important ways, maybe to have a conversation or to negotiate or to have compassion or whatever, okay? So when I think about that, when I believe that my disputants are doing their best, I'm actually better as a mediator for it. Because then what happens as a consequence is that I'm not worried about whether they're doing their best or not, and I don't have to think, come on, dig a little deeper, do a little better. Why did you do that? Why didn't you do that? I'm talking about the things in my head, right? I have to battle those if I don't have a better perspective, a non-judgmental perspective. And so the challenge that I would suggest is that if you as a mediator believe that they are doing their best, even if their best is different than your best, you can handle that neutrality role better because you don't have to worry about getting them to do better. You just know, I bring people into the setting and I try to help them get to a better place than when they arrived. Now, this kind of goes to a more philosophical area that I'm going to go into today a little bit, and that is the question about why you would mediate at all, personally. And is it really for the other person, or are you doing it for you? And that's going to be related to this idea also. Because if we can be forgiving and we can suspend judgment and have the perspective that people are doing their best, then we can actually, as we work with them, try to get them to a better place that is different from our place. So it sort of begs some interesting questions about why you would mediate, what your goals are, what you believe are sort of your moral obligations as a citizen, as a communicator. For me, it's kind of interesting to say, does the suspension of judgment then give us more inclination towards mercy, for example? I know you didn't expect me to cover mercy in this talk, but I'm going to. And this goes to kind of something I've been thinking about for a number of decades, this idea that when I suspend judgment, all of a sudden, because I don't have to think about whether people are doing their best anymore, I have the space now for compassion and mercy. What does that mean? That means that I am able to serve people in a much better way because I don't have to worry about whether they're right or wrong or better or not better. I actually have the space to say, wherever you are, I'm here to provide you compassion and mercy. Now, this goes to a larger question that I have asked myself for a lot of years. I spend my whole career helping people become better communicators. And one of the questions that I have for my graduating seniors around now is, what will you do with all those communication skills? And the question I'm posing to them is, what will you do with those communication skills? Will you use those skills for your own benefit? Or will you think about those skills as a benefit to yourself and to others? It's sort of like the notion that you and I could set out to become rich, and we get a bunch of money, and then the question is, what will you do with that money, right, now that you're rich? What will you do with the money? Will you keep it? Will you give it out? Will you do something in between? But I think that as a mediator, that's a very interesting and challenging question to say, think about what your motives are and think about what happens when you and I are judgmental and what happens when we think about just keeping our skills to ourselves. For me, I sort of arrived at the place to say the skills actually aren't worth probably developing just for me. They're probably, I mean, they're beneficial to me, of course, but if I develop skills and I can also benefit others, then I have a much higher level of contribution than just having the skills for myself. The only way I can get there is through suspending the judgment, though, because I can't worry about why I'm skilled and you're not. And not that it's that way, of course, but why I have more skills and you have less skills, or why I know this thing and you don't. I don't worry about any of that. What I think is, here I am today, and I have the opportunity to show mercy and compassion to another individual, and that is worth doing. Okay, so let's talk a little bit more about neutral phrasing. When we talk about neutral phrasing, what we're doing is asking how that event or fact or detail should be placed in context. So what does that mean? That we don't place it in context in our context, because it doesn't matter, right? You're not building your narrative for yourself. You're building the story for them, right? It's their storytelling. So when you think about it, when they say, oh, I think it's a terrible decision, you can say, what do you mean by terrible decision? When they talk about a problem, you can ask if that problem has happened before. Don't assume that it has. Don't assume that it hasn't. You got to get all those assumptions and judgments out of there and ask just general questions. What would you like to change? Do you see a way of doing that that's different? Tell me about what happened last Sunday. These are all things that we want to ask that are very phrased in a way to kind of get away from our context and back into theirs. Okay, so the last topic that we're going to talk about today is this notion of positions and interests. And I know this is a review for a whole bunch of you because you've seen this in Yuri's book, Getting to Yes, and some other documents from him. And this is basically the notion that individuals tend to use positional phrasing, especially in disputes, and the problem is that they become entrenched with their positions. So when somebody says $500 and somebody says $1,000, those are positional statements. And so you as a mediator, your task is to not use phrasing that reinforces those positions, but your goal is to try to get a common interest so that you can make some movements, right? So you can actually make a deal between them, and we'll talk more about that when we get to stage 4. So I want to give you an example from our high schooler. So we have a high school senior at home, and one of days recently, he said that he was going to be out with friends watching a movie. And so I said, hey, so be home by 11:30, or I don't know what even time I said. I said, be home by 11:30. And he said, well, I want to be home at 12:30. And you can hear the positional phrasing going on right in that conversation. So I said to him, no, I really want it to be 11:30. Parents, by the way, are very famous for positional phrasing. I know you know that already. So now what's great about being a teacher of communication is that my own children turn on me sometimes with those same skills that I've taught them. So what did Johnny say, my son? What did he say back to me in that moment? He said, don't you care about whether I'm safe? And all of a sudden, I froze for a second. And I thought to myself, he's got a common interest. I do care about his safety. And so he went on to tell me that the movie was over at about 11:15 or 11. It was close enough to the time that I had given him that it wouldn't be safe for him to drive at that speed home in order to meet my position, essentially. And so when we think about that notion, I think it's pretty interesting to think about, can we identify interests on a more central level in our mediations to help people move? I always say that that in the mediation, it slides on the interests, but it holds on the positions. And so that's kind of the challenge as we think about positional versus interests. You heard me talk about neighbors, and neighbors talk about this idea a lot. They say, I just want peace. And then, of course, that opens a door for me as a mediator. When I get to stage 4, I can say, tell me what peace would look like for you. Tell me what you want that would achieve that. And again, I don't think about what I consider to be peaceful. I actually ask them what they do. And that's not the same necessarily. And I'm okay with that. All right. So this last section of the show is one that we've done before, and that is where we're going to do this process where we call Ask a Mediator. And these are some different questions that I've covered some of these in previous episodes. I have a couple of repeat questions here, but I want to go over them again to make sure these are based on the discussion board and different messages that you've given me. So I'm just going to go through these questions as we conclude the show to identify some areas that might be interesting to you. Okay, so first question, what about liability? Can I be subpoenaed? And this is an interesting question. So when you do the pre-mediation agreement, your job as a mediator is to get those signatures and to go over the fact that yes, you can be subpoenaed, but no, you cannot testify. So in that pre-mediated agreement is the confidentiality statement, and if you bring that to the judge signed, then you would have the excuse in your hand. And that is to say, here, they signed off that mediation is a separate process. You and I have talked about that notion of confidentiality before, that we're going to keep the mediation separate, and therefore I cannot testify. So yes, you can be subpoenaed, but no, you wouldn't have to testify. And so I'll say that often in my mediations in the courthouse especially. I'll say, you can subpoena me, but I'm not able to serve as a witness. I can't be a party to any aspect of this case now or in the future. And use that phrasing to help them understand that. Okay, next question. What is the typical hourly rate of a mediator? And this is a great question. One that I would say you probably need to do research depending on what area you plan to mediate in. So for example, individuals who do mediation in Los Angeles earn from about $150 to $275 an hour. But that's in Los Angeles, and that's for an experienced mediator. So you might see some variation in the cost structure. Some people give the first hour free and then charge a rate. And what I would just say is do research and think about identifying like your area and what kind of mediation you're talking about in order to understand how to set a fee. Another question that I get is, how do you improve eye contact in the opening statement? And this is something that I use as a strategy when I have a printed opening statement that I'm doing, and that doesn't always happen in mediations that I do. But a printed mediation, I frequently will bold certain words that I know what the concept is so that I will be able to speak more from the document that is in front of everybody rather than just reading it to them. And so what am I doing? I bold words like third party. I bold words like confidential, neutral. All of those things I bold, and they're any of the main concepts so that my disputants are able to kind of relate to me. Of course, related to that is what is included in this notion of a sense of communication. And this is where I'm going to talk about your connection with the individuals. You need to develop some phrasing and delivery that promotes connection. And I'm not saying you side with the individuals, okay? So it's not like you're trying to get to be their friend. You're not trying to connect with them in any interpersonal way that's outside of that mediation. But essentially what you're doing is trying to help them feel valued. That's how I think of it. And so I value you when I look at you when you're talking to me. I value you when I don't read off my opening statement page, but I practiced it enough to be conversant with the document. I value you when I say things like, I hear what you're saying. And you need to have a number of phrases available that are like that phrase, I hear what you're saying, so that you can promote that rapport or connection. Very, very important in mediation. Okay. Next question, what is the education level that we should use in mediation? And I would say it depends. But I would also say it is important that you don't use too many words that people don't understand. So for example, something that comes up in small claims often is, are we going to dismiss it with or without prejudice? The judge will say that phrasing. And some people hear the word also adjudication. Even arbitration and mediation, like some of the words that we use in a court setting aren't necessarily words that people know, and they might act like they know them, but I have found people sometimes will just nod and act like they know what those words mean, even if they don't know what they mean. And so my comment would be just a warning not to get too fancy with your language, because you need to help real people today. And I'm not saying to talk down to people either. You might adjust up a little bit if you find that your disputants or both have a high education level. But what I would say is be careful about the context, because again, you're trying to get that connection with those disputants. Okay, next question. When do you shuttle and when do you mediate together? So this is an interesting question. Sometimes we shuttle by putting, and that's what I call it, books call it different things, but they might call it a private caucus, right? Or a permanent caucus where we're separate. When I say shuttling, I'm talking about putting parties in separate rooms and I move between the rooms. And so what does that mean? That I am speaking with them individually and I'm the only common ground. Now, this is much more work in mediation because they're not there to hear each other talk. But there are instances where it matters to do shuttling. So some cases that I've worked on that have involved violence or the threat of violence, or persistent ongoing harassment behavior, all of those would qualify potentially as a reason to shuttle. And so I might do less shuttling like in small claims where there are more dental, car accidents, smaller issues between neighbors, maybe repairs, contracting, landlord-tenant, not evictions, but other issues with deposits or payments. And I might do all of those together where the parties are both present. But when I'm in civil harassment, far more common for me to do shuttling. And that is also to help manage the emotional expression. This is something we'll talk about in future episodes. Okay, so I talked about eye contact. What do you do when somebody says in storytelling they bring a binder of information? So this happens sometimes, especially in cases that have gone on a number of years or involve a lot of receipts. And I have individuals who will sometimes bring a big binder and say, I have everything in my binder. That's my story, or that's what I have to say today. And that's an interesting dilemma for you as a mediator, because what they're essentially saying is I have all these pieces of paper. Now, when I'm doing small claims, I don't want to read every piece of paper. And I might find that that's terribly inefficient for me. So you would hear me very often, if I was facing a disputant who had a binder of information that they handed me, they would say, well, I have all this evidence of X, Y, and Z. And I might say, okay, so if I were to read every page in that binder, what would I conclude? And then they tell you usually the answer, and then I'll say, okay, so I'm going to leave it right there where it is, and we'll refer to it as needed. Essentially, what is it? It's a binder full of examples of the overarching thing that they said to you. Now, I had another case a while back where the parties were sending each other pornographic videos. And they were also sending like harassing kind of videos. It was a civil harassment case. And they asked if I wanted to see the pornographic videos. And I said, no, I do not want to see the videos. Tell me what I would conclude if I were to watch all of them. And I've had the same thing in neighbor-neighbor disputes. And usually they give a summary. In fact, in that case, they've said, well, you could see that we send mean messages to each other. And then I understand what to do with those things. Sometimes people will have text messages that they'll have pages and pages, sometimes hundreds of pages of text messages. And if you ask what would we conclude from the stack of text messages, frequently they would say that we say negative things, or that we bicker a lot, or that we have a very difficult relationship. And often that's enough, to be honest. I don't necessarily need to get into the details to read all of those. I might, but not necessarily. Okay, and then the last question is a really interesting one that has come up this past week. Is it really harmful on a mediation if you have a good suggestion? Or is it harmful to offer a second opinion? And I find that to be a very, very interesting question. So I guess my question back, if I were to ask that person the context of the question, would be harmful to whom? Okay, so is it harmful to make a good suggestion? What I would say is it's not harmful to you because you probably like that, but it might be harmful to your disputing parties. But here's the thing that's interesting is I hear mediators say, well, I had a great idea. I know how to solve their problem. It will absolutely help them. And my comment would be, but that's not your role as a neutral third party. So you have to think about, like, what is your role actually in that moment? And your moment is to help them engineer an outcome that they will follow through on. So that's where it falls apart on the harm side. From my experience, if a mediator suggests something and it's not original to the disputing parties, then they have less durability or less chance that resolution will be durable or lasting for those parties. So that's kind of an interesting thing to think about, to say that if I believe I'm doing them good, it might result in harm, however. And so that's kind of an interesting question for you to ask yourself as a mediator. Now, of course, a big challenge that all of us have is, let's say you're 10 minutes into a mediation and you think of a great solution, but you don't say it because you're a neutral third party. The challenge is to stay in that mediation for 30 more minutes and then maybe have a disputant think of that idea. But the process of doing that and engineering a session where they have that outcome and it's really the buy-in, then I would say it's worth that wait, even though you had that idea originally. So you might say, gosh, that's frustrating. I had such a great idea so long ago and it took them 45 minutes to get to that place. The 45 minutes are worth it because that's their outcome, and where it really pays off is they leave and they can actually engineer that resolution and have it become their own. And when it's their own, they have a much higher chance of keeping that peace or whatever it is they're after. All right, well, this concludes our session for today on storytelling and the details of storytelling. I'll look forward to seeing you again soon.
Great job.
And we're done.